Hello, everybody. This is going to be really fun. My name is Michael Wasylik. I'm one of the lawyers at Ricardo and Wasylik here in Florida. And together with my partner, Jason Ricardo, I help people just like you overcome debt collection with dignity. And today we're going to do something really fun. We're playing around with going live. And what I want to do is I want to go ahead and answer the questions that some of you may have regarding debt collection. And so what I want to do is I want to see when, right now I'm going to want to see as people pop in, go ahead and make sure to filter in the comments here. I know that this time, a lot of people are at work and maybe, not necessarily watching live, but I want to make sure that there we go. We got somebody on, I think. So if you're watching this, go ahead and pop a comment in the comment section. Let me know that's working, because I want to try and make sure that I can respond to all the questions that come up. And so while we're doing that, while we're looking for that to happen, what I want to tell you about today is, we do debt defense and debt collection here in the firm. And what that means is we represent people who are being sued by debt collectors, people who are being harassed or abused by debt collectors, people who are experiencing a negative debt collection experience. And we want to help them fix that and overcome that debt collection, put it in the past. And generally speaking, there are three ways that most people receive communications from debt collectors. The three ways most people interact with debt collectors. And the first one of those, the one we see very often because we're lawyers and people call us when this happens, is that people have court action with debt collectors. Number two is when debt collectors appear on their credit reporting. And number three is when there's debt collection communications. I want to take each one of those in turn. So court action is when a debt collector sues to collect money from you. They go to court, they take you usually to small claims court. It's in Florida right now, small claims is $8,000 or less. And so if there's a credit card debt or something like that that's less than $8,000, they will sue the individual in small claims court and then try to get a judgment. And then once that judgment is entered, they will try to do things like garnish wages and collect that money involuntarily from the person that they sued. That's kind of number one. And then number two is credit reporting, where a debt collector lists a debt on a credit report as being in collections or past due. It's a negative marked on your credit report. And those kind of things can end up affecting your ability to get credit, either a home loan or an auto loan or even a credit card. They can affect your ability to rent an apartment. They can even affect your ability to get a job, or if you have a security clearance, they can affect that as well. And so we see that there are consequences to those negative items on a credit report. Now, just because an item is negative and on the credit report doesn't mean necessarily that there's a way to get it off. However, it is absolutely legal to remove or to request removal of anything that's inaccurate, obsolete, or otherwise unverifiable. And we can dig into that in a minute as we get into any questions that you all have. I see here that Gil has just popped on. Gil, thank you for, let me just pop that question up, pop that up real quick. Gil, hi, thanks for popping in and let me know that everything is working. And so if you have a question, Gil, go ahead and pop it into the, questions, the comment section below. The third thing that people experience besides the court action and credit reporting is they have communications. That means a debt collector is sending letters, is making phone calls, and or is otherwise communicating with them. Sometimes it's text message. Now social media is a way that debt collectors will reach out to you. And so those communications are a way in which the debt collector is going out and contacting you to do a couple of things. Number one, they want to inform you about the collection, about the debt. And the reason they want to inform you of that is because they want you to know that they are trying to reach you, that they're trying to collect the debt. And then from there, depending on the debt collector, they're going to use a spectrum of techniques to try and motivate you to pay. And on the, kind of the least offensive end, it's simply giving you the information about the debt and relying on you to voluntarily make a payment because, you are aware of the debt, and, let's say, it's a legitimate debt and you just had a momentary blip and you want to take care of it. And so you'll contact them. It gives you a channel to reach out to them to establish that payment. And then the on the other end of the spectrum, and there's all kinds of tactics in between, is they want to motivate you to pay the debt by negatively impacting your emotions, by using fear, by using abuse or harassment or anger. They want to stir up that emotion in you so that you want nothing more than just to get rid of them, whether it's because you're afraid of what they're going to do to you, because they've either lied to you or ratcheted up your fear, or because you're just so pissed off about the way they're dealing with you. You just want them out of your lives for good, and you're going to do anything to get rid of them. And so that's kind of what they do. So I'm looking at to see, we got a few people watching the live broadcast now. So if you want to go ahead and, again, if you have a question, go ahead and drop it in the comments section below, and I'm going to start taking those questions as they come in. Keep in mind, I'm in Florida, and so questions of Florida law are going to apply mostly when you get sued. Some of the credit reporting and some of the debt collection communications stuff is going to be federal and may apply outside of Florida, but I'm a Florida lawyer. I can only really talk about Florida law. So I'm going to start here. I see we've got a couple comments there. Is it a violation when Lvnv has a process server come to where you don't live, but they do a vehicle registration search and attempt to validate the address as your place of residence to serve you? So first of all, they're only allowed to sue you where you live. And by that, under the FDCPA, they have to sue you in the judicial district where you live. So in Florida, for example, if it's a small claims matter, they have to pick the correct county to sue you in. And so if I'm here in Pasco County, which is just north of Tampa. So if somebody lives anywhere here in Pasco County, that lawsuit would have to be filed in Pasco County. Now, if you still live in Pasco County, but let's say you moved across the street and they serve you at the wrong address, then that's not a violation. They have a duty to find out where you live and serve you in the proper place. So if they figure out you moved across the street and they can serve you there, that's valid service, and that's not a violation of the law. Now, what may be a problem is if they sue you in Pasco County and they later discover you live in, say, Hillsborough County, well, then they would have to either drop the Pasco County lawsuit or transfer it to Hillsborough County once they find out where you actually live. Now, the caveat to that is they can also sue you in the place where the debt was incurred, the contract was formed. So if you lived in Pasco County at the time you took out the credit card, they could legally sue you there, and that would be okay under the FDCPA. So Divine Legacy Builders, I hope that answers the question. There's another part of the question here. To serve you court papers and tell the, I'm sorry, I missed the rest of this question. They tell the actual homeowner your business, and it's court papers they can't leave because the address is my mailing address, not my personal address. So if they have a process server deliver court papers to a place you do not live, and they tell the person there about what's in the papers, that can be a disclosure of your debt to a third party. But the person, if the person who answers the door says yes, Divine Legacy Builders lives here, the process server has no reason to believe that they're doing anything wrong. And so that would be something that would probably end up not being a violation if the person who answers the door says, yes, this person lives here, they're not home, but I can take the papers, because under Florida law, that would be valid service of process. So I'm going to go ahead and for the moment, we'll put a pin in that, but I hope that answers the question completely. Let's see. I'm going to go to Carlitos here. So Carlitos has a two-part question. I have an account with a collection company, but now they're trying to collect another account. How can I put that on hold? So not enough information. So collection company. Well, first of all, who are you dealing with? Go ahead and throw that in the chat. Who are you dealing with? And I'm going to come back, Carlito, to that question in just a moment. Next question. What should you do when a credit bureau sends you a stall tactic letter after you disputed a collection? Well, when you say stall tactic letter, I'm assuming they say, well, we need more time to investigate. Now, that actually is a good thing if they are actually investigating, because what happens is that under the FCRA, which is the federal law that governs credit reporting bureaus, when you dispute a debt, they have a duty to conduct a so-called reasonable investigation. And when they do that, if they can't verify the information, they have to remove it. And if they discover it's incorrect, but they're able to correct it, they can correct it. And so they're actually doing the right thing by taking additional time to investigate it. Now, during that time, they need to mark your item as being investigated in dispute. But once they have that dispute, they must do a reasonable investigation within a reasonable time. And if they can't within a reasonable time investigate it, then they're supposed to remove it. So your real question, I think, is what happens when they don't do the thing they're supposed to do under the law? What happens if their investigation is unreasonable? What happens if they fail to make any investigation at all? In that case, once you have disputed it and they violate the law, you then have a right to sue them in federal court under the FCRA. If you're not willing to do that, then you're probably not going to get the results you want. If they're not afraid of you, you're probably not going to get the results you want. In fact, the vast majority of credit disputes right now, disputes on credit reports, are being ignored. There was a CFPB, Consumer Financial Protection Bureau report a short while ago that talks about how things were ignored. In fact, I have a, let me do this. I have a video. I'm just going to pull this up on the screen real quick and show you that I shot a video about what you should do when the credit bureaus ignore you. Now, you're not being ignored, but here we go. This is the one. So let me share that screen real quick here. I'm going to show you the so this is our YouTube channel, and it's this Make Them Respect You video. And so if you go to that, it says Equifax, Experian, and TransUnion ignored our disputes. So if you're being ignored completely, go watch this video. And I'm going to just pop that up. That's the video you're going to want to watch. And so that's the one you'll need to check out. And that will be the video that kind of tells you what to do when a credit bureau is not doing the right thing. So I hope that's probably more information than you were looking for, but I think that's hopefully that'll be information. So Divine Legacy Builders comes back to, can they do vehicle searches? Vehicle searches are public. Vehicle registrations are public record. Private investigators use things like that for skip traces all the time. Process servers use those for service of process all the time. There's no law that I'm aware of that prevents a process server from looking up your vehicle in the registration. Nothing at all. That's why it's important, by the way, to have your vehicle registered to the address you want it to. Now, some people believe in registering their vehicle to an address that's not necessarily where they live, so it's more private. Like if you have a car that's owned by a business, you can register it to the office address, things like that. If you don't want to disclose your actual residence to somebody, your voter registration is public record in terms of where your address is, so they can look you up that way. Your driver's license, that's something that process servers and private investigators can get. There's all kinds of public information about your address and where you live, and it's very, very difficult to hide your residential address because most of those are going to be public record. So hope that let's see. All right. Hope that answers the question. Carlito came back. Glasser and Glasser, they're in Virginia, but I live in North Carolina. So if you want to, when you say you want to put that on hold, Carlitos, again, there's a couple things going on here. So there are three things that they might be doing to you. Number one is they might be suing you, right? I imagine you'd already know if they were doing that. They're probably not yet doing that. Number two, they could be reporting items on your credit report. And number three, they could be communicating with you either by letter or by phone or other methods. And I'm going to talk a little bit about the communications aspect of that, because that's probably what you're talking about. Communications are the easiest thing to deal with, and they are also the probably the least consequential. In other words, just because they're communicating with you, unless they're actually manipulating you or really ramping you up, then what you're going to do is you're going to see here that that the FDCPA under section, let me put this on the screen here. Let me put a banner up. Boom, there we go. So this is the section that I'm pulling up right now, which is 15 U.S. Code 1692C, and then under 1692C, there's A, B, and then C, and it calls ceasing communication. If you want them to stop communicating with you, all you have to do is tell them in writing, right? Tell them in writing. You don't want to hear from them anymore. Now, they're obligated under the law to stop communicating with you under federal law. And so you can do that. Now, the danger of doing that is if they're not allowed to communicate with you because you've told them to stop, they might be more interested in taking other aggressive routes like, ensuring that it's reported on your credit report, and they might also even resort to a lawsuit. Depending on your state, in Florida, I think that's okay because a lawsuit is what we do, and we find those some of the easiest things to deal with, but or not the easiest, but the ones that often give us the range of complete relief. Again, we've got a video that talks about it's good to be sued, so you can check that out on the channel as well. So if you want to stop them from communicating with you, you can go ahead and notify them in writing. Don't talk to me anymore. I don't want to hear from you anymore. You can lawyer up. You can hire a lawyer in your state and say, listen, my lawyer's going to handle this. Don't talk to me. Talk to my lawyer. You can do, you can say, I don't want you to call me, but you can write to me. Right now, that's what I generally recommend, by the way, is make sure, when you're dealing with a debt collector, you don't want to cut off all communications. Tell them, don't call, don't text, don't send me social media. Go ahead and communicate with me only by mail. And the reason to do that is because every communication from a debt collector is an opportunity for them to break the law and for you to countersue them. Because anytime they send you a written notice, if they have broken the law in that written notice, it's preserved for all time. Now, you have a limited time to actually bring that lawsuit, but they can't deny what they put in writing. And if it's in writing and it broke the law, then you've got a record of it. And so when you want debt collectors to stop communicating with you, don't cut off all lines of communication. Just say, never call me, never text me, never email me, never, although email also has the advantage. If they send you an email, you can print that out and show when you received it and all that. But you can say, the only way I want to hear from you is by mail. And once you get those letters, you can save those and have a lawyer take a look at them, and either individually or maybe in the context of some larger picture. If they're breaking the law, you can sue them. And I tell you what, there's nothing that stops a debt collector dead in its tracks like getting sued. So that's something that you can use there. So when you talk about putting that on hold, I hope, Carlitos, that's what that was an answer to your question there. And so I'm going to take a look here. We've got one from TDIR again. When they claim you're being helped by a credit repair company, so they want proof of identity. Well, proof of identity is something you generally are going to want to put in there anyway. Now, what I'd recommend is go, tell them that you're not. Let me take a step back. The credit bureaus have this built-in excuse to say that we don't have to respond to your disputes if you're being helped by a credit repair company, right? And that's partially due to abuses by the credit repair industry, but it's also due to lobbying by the credit bureaus. And so what they do is they pretend everybody's being helped by a credit repair company. So how do you do that? Well, first of all, put in your letter, I am writing this on my own, if that's true, or or put something in there that put something in your letter that says, I'm not being helped by anybody. I'm writing this letter. I've not hired anybody to help me out. This is my letter to you. And, then, of course, they have to have proof of identity. That's something that they're going to insist on anyway. Technically, I don't think that's required under the FCRA, but obviously they cannot disclose sensitive information to anybody unless they know that they're dealing with you, and so on and so forth. And in fact, sometimes they hide behind that identity proof to avoid some of their obligations like disclosures and all that. So, generally speaking, it never hurts to, they already know your address, right? Let me take a step back. You should always have obtained your original credit report directly from the three bureaus. We recommend annualcreditreport.com. Let me throw that up. So go to annualcreditreport.com, follow the steps there, and you can go ahead and download your 3 credit reports. We've got a whole video on how to jump through all the hoops and some of the things that people fail in doing, some of the things that trip people up and how to avoid them. So go watch that video. Again, it's on the channel. And you're already watching this on the channel. So just follow the link to the channel and you'll be able to see that video in the video list. But when you get your credit report, you'll see that they already have your address. They know where you live. So, and sending a copy of your driver's license or other state ID is not a bad thing. They have the information anyway. So go ahead and close that and mail that off with your dispute letter. Say, this is me. I'm the only one writing this letter. I'm writing it on my own behalf, and I want you to fix this. And, if you're doing a second round, like you might be doing, then go ahead and say, listen, you've accused me of using a credit repair agency. I am not. This is me, right? And just put it in there. Because here's the thing. Once you say that to them, they have 2 choices. They can either treat it like it's yours, or they can accuse you of lying. And then if they accuse you of lying without good reason, and you're telling the truth, and they continue to ignore you, and you eventually sue them because they keep accusing you of lying when you're not. Once you get in front of a jury and say, listen, I tried time and time and time and time again to get them to do the right thing, and they kept saying I was using somebody, and I wasn't. It was just me. Everybody will feel that frustration, and they will take it out on the credit bureau on your behalf. So, I recommend, saying, listen, this is just me. Respond to that by saying, this is just me. There's nobody else involved. Again, if that's true, and see what they do with that. And if they accuse you of lying to them, I think that's a point you could probably, if you suffer damages as a result of their failure to correct the dispute, I'd say you probably can go straight into federal court from there and make them pay for ignoring you. They will probably not mess with you again. So I hope that was helpful. So I'm looking at the comments. Looks like we've run out of questions. We're running about the 25-minute mark, but so if there's any other questions, I'd be happy to go ahead and take those. And let me just check out the. Let me see here. Yeah, it looks like we've addressed all the questions. I see there's a handful of people that haven't yet asked a question. So if you got a question, or you're just if you're just watching this and hey, you want to say hi, that'd be great. But otherwise, I hope this has been helpful for you. One of the things we want to do is we want to kind of talk to the people that are actually getting affected by debt collection. So, there's a couple of things I just looking back at what we saw here, number one, we have somebody talking about getting sued in the process server delivers to the wrong location. We've talked about some communications from a debt collector, and we've also talked about credit reporting. And so we've touched on each of the 3 buckets of debt collection, court action, credit reporting, and communications. And so, those are the big 3 ways in which most people are affected. So listen, I'm going to try, this is kind of an experiment, just seeing whether or not people were going to be interested in having a live Q&A. So if this was helpful for you, go ahead and once the replay goes up, go ahead and drop a a comment and just say, hey, listen, I want to see more of these. If you're watching this on a replay and you'd like to see this happen again, let me know. Tell me a couple things. Number one, what state are you in? Number two, what type of issue are you facing? Are you facing court action? Are you facing credit reporting? Are you facing communications from a debt collector? And then also, tell me is this a good time? I mean, Tuesday at 10 is when I like to kind of roll things out, but I know people work and there may be better times. So tell me if there's a good time for you. What's the best time for a live stream? Hey, is it the evenings? Is it on the weekends? Is it during the day like this? And so I'll try to respond to that. And so if you're watching that on the live stream, or if you're watching the replay of the live stream, you can also do that as well. So let me go ahead. And also too, if you want to reach out to us, if you're in Florida and you are trying to reach out to us, our website, ricardolaw.com, you can go there. And in fact, let me go ahead and pull up the contact form. So this, it would help if I could type correctly. All right. And so now we've got, this is our website. This is the contact form. So if you go to our website and contact us this way, you can go there. And so there's a click to call link here. And by the way, this is also something, if you just go to ricardolaw.com/call on your cell phone, you can click to call us right there. If you're in Florida and you're facing debt collection, we would like to hear from you. If you just want to contact us, there's an email form right here you can fill out, and you can do that on your phone, whatever. Just drop an email address, a first name, and then whatever message you've got, and then we'll try to answer those as well. So those are ways to contact us. And again, if you're in Florida and you're experiencing debt collection, court action, communications, or credit reporting, we are eager to hear what you have to say and ways we can help you out. All right, let's see. I've got another comment here from Marcos. Let's pull that up. There we go. Okay. Good morning. My account went into default in 2017. I want to take care of my collections so that I can pursue a career that won't hire me with active collection. So this is somebody who's facing, the prospect of not getting the job they want because of their active collections. If I set up with a payment plan, does that reset the 7-year statute that will keep this record of my credit report? Okay, this is a great question because there's a lot of confusion about what the statute of limitations means and what the time limit for credit reporting is. The time limit for credit reporting is 7 years from the date of first delinquency. And the statute of limitations, the time limit for credit reporting is 7 years. After that 7 years, it has to come off. That's federal law that says a bad debt cannot be reported for more than 7 years from the date of first delinquency. And that's the first time you miss the payment and you never catch up. Okay. So that's the, and by the way, if you do catch up, that delinquency still has to roll off. In other words, once you catch up on a debt, if you do, then once the 7 years passes from the time you first missed that payment, the negative part has to come off. They can only report negative stuff for 7 years, and nothing resets that. What would, if you made a new contract and then breached that new contract, then that'd be a new delinquency, and that'd be a new negative item to report on your credit. The statute of limitations is a time limit for them to sue you. And a couple things do reset that, and it's state by state law. Like state law varies. In Florida, generally speaking, payment or some voluntary agreement to waive the statute of limitations are the two things that would ordinarily extend that statute of limitations. So making an agreement does not extend the time for it to appear on your credit report. And so anybody watching this, it's very important to understand there is no statute of limitations for credit reporting. There is a 7-year time limit. They are different, and different rules apply, and nothing resets the credit reporting time limit. So Marcus, thank you for that question. All right. Coco's got a question about medical debt. Best way to fight medical debt collection. So that's a great question. Medical debt collection is just debt collection. And so it depends on how they're interacting with you. So again, if they're interacting with you by taking you to court for suing you, then then you have to respond to that lawsuit. If they are communicating with you and trying to request that you pay the debt or even manipulate you into paying the debt, then the FDCPA governs how they communicate with you. And if they're reporting on your credit report, which is most likely, then there are methods to address that. And so the most common thing to come up in medical collections is a question of whether the debt is actually owed because it should have been covered by insurance, or the medical provider made some mistake in billing that should have been, the medical provider should have billed the insurance company and failed to, or the medical provider, and this does happen. It's unusual and rare because it's evil. A medical provider bills you for something they didn't actually do. There's another lawyer I know whose wife had a high-risk pregnancy, and she went into the hospital, and the baby was born, and actually everything worked out, thank goodness. The baby was born, and they whisked that baby immediately to the newborn ICU. They never went to nursery, which is where ordinarily a baby would go if there was a normal birth. But when the bill came, she got a $3,000 bill for nursery care, even though they never went into the nursery. So look at your bills, make sure you got everything make sure that you received every service that you were billed for, first and foremost. Secondly, investigate with your insurance company about whether or not the healthcare provider made a proper claim. And anything that was supposed to be covered that was not, you have to work with your insurance provider and your healthcare provider to make sure that they do the right thing in claiming that. Because if they're trying to collect a debt from you that they should have gotten from insurance, that's a debt that's not properly owed. And if they turn that over to a debt collector and you challenge that properly, then that's something that might be a violation under the FDCPA. Here in Florida, there are other laws that would prevent a healthcare provider from billing you for something that they knew or should know wasn't rightfully due and owing. So that's something. Okay, so Coco says, I'm in Florida. So yeah, so here in Florida, if a healthcare provider bills you for something they shouldn't bill you for, in theory, they're violating state debt collection law. And so that is something that I'd look out for. I would take that approach. Now, here's another thing. So we've also learned that due to pressure from the CFPB, the way medical bills will be reported has changed. So Coco, tell me this. Do you know whether the bill is over or under $500? Pop that in the chat, and I'll tell you why. Because so the credit bureaus have announced they're going to start changing the way that credit reporting works for medical bills. Specifically, they're going to start removing debts once they're paid. In other words, if you pay it off, it's off your credit report. And that's a voluntary measure by the bureaus. The second thing they're going to be doing is instead of waiting only 6 months to report it past due, once they're going to give you a 12-month grace period to figure out the resolution there. So if your healthcare provider bills you for something, the insurance is supposed to cover it, and they don't, you have 12 months to figure that out before it appears on your credit report. And then the third thing that's going to happen is starting in, I believe it's June of 2023, and I'm going to roll out a video about this. The bureaus are going to voluntarily not report any debt below, I think it's $500. Excuse me. So that the medical billing situation will be alleviated significantly. So to recap, you'll have 12 months before it appears. You'll have the ability to pay it to make it go away, and then you'll not see it at all if it's under $500. All of those are voluntary measures by the bureaus, and so that should address some of the worst part about credit reporting. Now, Coco, you haven't mentioned how the collections are, how they're working. So if you want to add that in, go ahead. Divine Legacy Builders asks, oh my God, I almost forgot. Is it a violation for Midland Credit to call daily from different numbers? So there's two questions there. One is, can they call daily? And two, can they call from different numbers? And so the daily calls under rules just changed by the Consumer Finance Protection Bureau. They've issued rules that implement the FDCPA, which talks about communications with with debt collection. So let me go back to the communications part of the FDCPA here. And so this talks about they're not allowed to communicate with you. Let's see, I'm actually looking at the wrong section. So I'll just take that off screen. But right now they can call you up to once a day. More precisely, they can try to reach you up to once a day, and your phone can ring up to once a day. If they talk to you, then the limit is, I believe it drops to, I have to look it up. I think it's twice a week, but there's a definite there's a definite number in the rule of the number of times they can actually either speak to you or try to speak to you. And those are different numbers. So as far as calling you daily, as long as they're trying to call you but not actually getting you, that's within the numbers in the rule. Now the other question is, can they use different phone numbers? Well, sure, they can use any phone number they want, but is it misleading? Is it deceptive if they're using phone numbers that aren't actually them? So what happens when you dial the number back? When you dial the number back, are you actually reaching them? Are you getting an actual Midland person answering the phone? Are you getting Midland's office? Are you getting their voicemail tree? Because obviously they're calling from different numbers so that they're avoiding the blocking, right? But Florida, for example, recently just passed a law that doesn't apply to debt collections. It applies to telemarketers, saying they're not allowed to conceal their number. So if they call from a number, it has to actually ring at their office. And I would say that if Midland is using a number that doesn't actually ring back to them, you can't actually call them back. I would argue that that's misleading and deceptive. And so, that's probably something that, especially if there were other violations, I might consider suing them for. But if it actually, when you dial the number back, if you actually get Midland, it's probably not a violation. Because as long as the number legitimately gets to them, it's a real phone number, and that's all that they need. So Coco comes back and says, one's under $500, the other's for $2,000. Well, so Coco, what you can do is, so medical bills, one of the questions about medical bills is, what does Hipaa do? Hipaa being the, let me do this. Let's see, it's the, and it stands for Health Insurance Portability and Accountability Act. And what that does is, it provides for rights to a patient with a medical provider. And so what you'll want to do is, and I think this is actually, and this is going to answer another question as well. I'm going to pull that question up as well. So Lvnv sent me a history of medical procedures. Is this a HIPAA violation? So HIPAA, first of all, 1P, 2As, that'll help you when you're actually Googling it. If somebody says HIPPA, you'll know that they don't know what they're talking about. Under HIPAA, you have two rights. Number one, you have a right that your medical information is private. The healthcare provider is not supposed to disclose that. Number two, you have a right to request your own medical records. So Coco, what I would do if I were you is I would ask your healthcare provider for an itemization of the billing, which under HIPAA you have a right to get. You have a right to get your medical records and your billing records. Get your billing records, get your medical records too, and see if they line up. Did you get the procedures that you were billed for? Maybe you need a medical professional to help you sort out, yes, this is proper bill, blah, 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 all that. And then go to your healthcare insurance provider, your insurance carrier, and say, did you pay for these? If not, why not? And they might come back and say, well, because the healthcare provider never asked us for it, or, you have a copay or whatever, right? And so you need to analyze, again, did you get what you were billed for? And then did your insurance company pay what it was supposed to pay? And if there's nothing wrong in those two things, all right, so I had to switch cameras real quick because I'm having an internet connection issue. There we go. Okay. Okay. All right. Now I'm back. Okay. Sorry about that. So, so you have a right to request your records. Now, going to Preacher G's question, is it a violation for Lvnv to send a history of medical procedures? So technically it is a violation for your healthcare provider to disclose your medical procedures to any third party, right? They can disclose the billing. They are not supposed to disclose your private medical information. What does that do for you? Not a damn thing, because you don't have a right to sue anybody under HIPAA. And so the fact that Lvnv has gotten these and is suing you, Lvnv debt collectors themselves are not generally, you can't sue a debt collector because they send they haven't done anything wrong by disclosing your private information to you. The medical provider probably has violated the law, and you can probably report them to licensing. All right, so I'm having some video issues here, and the short answer, Preacher G, is that if Lvnv sent you a list of your medical procedures, I'd look at that and say, did I get everything I was billed for? And if not, let them know. Say, listen, this is a false debt. Do not send, don't bill me for it again. But you can't sue Lvnv for having and sending to you your medical procedures. So I'm going to wrap this up. We're having some internet connection issues, but listen, again, if you want to see more of this and you're watching the replay, go ahead and put it in the comments below or punch it into the comment section now. Tell me if you liked it. Tell me if you want more of this. Tell me when a good time is. And also, too, you can mention to me what state you're in. That would be super helpful as well. So thank you for watching. I'll see you on the next one.